Record should reflect that the individual known to this court as Darrell Brooks is present in person in custody in street clothing, wearing a suit and tie and a mask.
For the record,
today.
I did not consent to being called that name, Your Honor.
All right,
And we still have yet to address subject matter jurisdiction.
The court has addressed it for the record. So
for the record, has it been proven?
Mr. Brooks, I stand by the written decision that I issued in this case last week. A second copy was provided. Please don't interrupt me. A second copy was provided to you. I know you saw it because you tore it up yesterday. So I'm not going to address it any further. You are mistaken and wrong about the law that it needs to be verified or proven.
Are you talking about the paper I accepted in return for value?
So with that, I believe, Mr. Brooks, I'm going to continue with this trial, whether you believe jurisdiction has been proven or not.
It has not been proven for the record.
And it has. So with that, Detective Carpenter was on the stand.
And it needs to be proven.
And I
per the prosecution
would like to have him brought back up unless there's any other issues the parties wish the court to address from the state.
I did want to address something briefly.
Go ahead.
As the court knows from our short discussions yesterday, the state will be playing a couple videos of the defendants and his statements. The court had previously heard those as part of a motion hearing, and I'm not sure if I'm really giving the defendant notice or what I'm doing, but I really tried hard, and I'm pulling out snippets from this because if the court recalls, there are a lot of references that the defendant makes to prior domestics with Erica, his prior record, things that the court had previously excluded. So I'm going through and I am pulling specific time ranges from this so that nothing that was previously ruled inadmissible comes in. And I guess obviously this defendant has the absolute right to cross-examine the witness. He has the right, and we've offered and we have been putting exhibits up for him. But I do want it to be noted that I would not be willing to have Mr. Brooks just say, oh, go to about the 7-minute mark, because if he even goes like 2 seconds before a clip that I had played or 2 seconds after, it could include information that was previously ruled inadmissible. And I guess what I would say to the defendant is the court has previously protected the defendant to make sure that things didn't come out, where he asked a question that could be construed as opening the door and the court said, we're not going to go there, Mr. Brooks, and he got the message. However, with this, if there's any portion of this video that's played that talks about the prior with Erica, I do consider that he has opened the door, and I will be asking the witness about it. So I guess this is maybe more so directed at Mr. Brooks, that if he plays clips that contain that information, he will have opened the door. He's had this video for weeks at least. These videos have been subject to a motion hearing. I'm not sure exactly what access he had to them before. I've reviewed the 5-hour video a number of times. I've been very meticulous in my timestamps that I'm grabbing out from here. And I am unwilling to have the defendant put Ms. Gussie in a spot where he's kind of, well, around this point. He needs to give exact times that he wants started and stopped. Because what happens is if he says, okay, can you pause here? By the time he says that, 5 seconds may have gone by, which may be enough to, some of these, if I would play 2 more seconds than what I have here, it would open the door. So I just want the defendant to realize that this is kind of a slippery slope here, and he proceeds at his own risk. And I'm not going to ask Ms. Gussie to stop it at a certain time because I think something's about to be said. That's on the defendants. And if he opens the door, I can assure you, I will go into it. So I did want to put that on the record, Judge, not to be a jerk about it, but just once it's out there, I can't not address it. And if it's the defendant who brings it out there into the view of the jury, then I'm going to feel compelled to address it. And then I didn't know if the court wanted to go through the preliminary instruction that you had provided previously on the interpreter. My understanding is that Mr. Marquez speaks very little English. If you want to add the added paragraph, that would be fine for the state. I've had 2 discussions with him, and I would not say he is, that English is a comfortable language for him.
All right, thank you. As to the first part, to what the state brings up regarding the redacted recording, I would remind Mr. Brooks the court did enter some rulings previously. Why do you have to roll your eyes at me? Let's start the morning off on a good
I
note,
didn't
sir.
roll my eyes at you, so I don't think it's fair that you should say I rolled my
I
eyes
saw
at
you roll your eyes at me. I'm
I
not going to
didn't roll
debate
my
about
eyes
it.
at you, so don't do that.
Well, Mr. Brooks, I'd appreciate a little bit more respect. These
I would too,
rulings,
Your Honor.
let me finish, because now you're interrupting me. These rulings were entered by the court to prevent other acts evidence from coming in. But a defendant can open the door in a variety of ways. These recordings, and I have reviewed them previously, do contain discussion and statements by you regarding these other acts. And as you heard from Attorney Basie, she has all of the timestamps to stop at appropriate times so that the state does not run afoul of those pretrial rulings. You can open the door by asking questions, by asking for a video to be played, and not knowing those exact timestamps. I think it's important that I reinforce what the state has just advised you of, so that when you are watching the recording, as all of us will be, if there is something you want replayed and you want to cross-examine the witness about, that you know those time stamps, and then the state has graciously indicated they would assist once again in replaying portions of that video. I don't need a response from you unless you feel you would like to give a response to any of that.